Welcome to this episode of Working Wise, a podcast exploring critical employment and labor law issues in today's workplace. My name is John Farrell, a board-certified labor and employment specialist in the K&L Gates Dallas office. Today, we will be discussing what can become one of the biggest headaches for any business, accommodating an employee's disability through leaves of absence. To orient the conversation, we should first review the background. Federal law, the Americans with Disabilities Act, defines a disabled person as someone suffering from a physical or mental impairment that substantially limits one or more major life activities. Employers have a duty to accommodate employees with disabilities. But what does this mean? Generally, it means that an employer should make some sort of modification or concession that enables the disabled individual to be able to perform the essential functions of the employee's job. Based on these definitions, it would be reasonable to believe that a leave of absence would never fall within the realm of a reasonable accommodation. Leave does not allow an employee to perform the essential functions of the job. Rather, it excuses the performance of any job function, including attendance. Nevertheless, the Equal Employment Opportunity Commission has long taken the position that leave can be a reasonable accommodation in the proper circumstances. Courts have agreed. Although the EEOC provides direct guidance on the issue, leave as a reasonable accommodation can be one of the most difficult areas to navigate. While there is no particular challenge when an employee needs a period of 1 week to resolve whatever issue is keeping them from work, the medical issues necessitating leave are often unpredictable, and the diagnosis changes on a frequent basis. An employee that initially needs 1 week may later need 1 month. It may also have been relatively simple for the business to cover for a week, but much more difficult to cover for a month. Another example may be an employee that initially needs 2 weeks, but then consistently returns with subsequent requests to extend for 2 weeks. 2 weeks was no issue, but the constant extensions essentially transformed the request from 2 weeks to an indefinite period. Before we delve into these more complicated issues, there are a few things that we know to be true. First, an employee cannot request indefinite leave. If an employee asks to be off of work without some estimation of the time needed, an employer is entitled to demand some estimation before considering the request. In addition, the employer is entitled to information regarding the expected duration of the impairment necessitating leave, and information that enables the employer to assess whether leave would enable the employee to perform the essential functions in the near future. Second, just because an employee's entitlement under state or federal leave laws, like the Family and Medical Leave Act, has been exhausted, it does not mean that the employer can deny requests for additional leave. Third, sick leave and maximum leave policies maintained by the employer cannot limit the amount of leave granted as a reasonable accommodation. For example, if an employer maintains a policy that states that an employee cannot be on leave for more than 6 months in a year, such policy cannot be used to defend a decision not to grant an employee leave in excess of 6 months as a reasonable accommodation. Fourth, paid leave in excess of what an employer offers as a benefit is not a reasonable accommodation. And finally, just because an employee requests leave as an accommodation, the employer can still offer alternative accommodations that effectively accommodate the disability and allow the employee to perform the essential functions if such accommodations exist. As I mentioned, short, definite requests are usually easy to accommodate. The issues arise with longer requests, extension requests, and rolling requests. Let's start with the definite, indefinite request. These take the form of at least 1 month of leave, or between 4 to 6 weeks of leave. The EEOC would likely take the position that these are definite requests, and courts have been inconsistent. They have found in some cases that these requests are definite, and in others they have found them to be indefinite. As an employer, it is best to do everything possible to narrow the scope of the request, while being cognizant of the fact that if the request ends in a narrow range, this should likely be treated as definite. Another headache is the request for excessive leave. The question is what constitutes a reasonable duration for a leave. but unfortunately there is no consensus. The EEOC has direct guidance on the subject, but does not take a position as to whether a certain amount of leave is per se unreasonable, and courts are all over the map. You can find case law stating that 4 to 5 months is reasonable, that 6 months is reasonable, that a request for an additional 4 weeks is reasonable despite the fact that the employee has been on leave already for a year, and there is even a case out of the First Circuit stating that 17 months is reasonable. However, some courts have taken a more measured approach. The 10th Circuit recently stated that it is difficult to conceive how a 6-month leave could be considered a reasonable accommodation. The 6th Circuit has also stated that while 6 months might be reasonable under the right circumstances, a year would seem to be unreasonable. An employer stuck with an employee requesting a long period of leave as an accommodation should likely focus on the evidence that the leave will be effective. There are several cases where the employers have been able to defeat a failure to accommodate claim by focusing the court not on the length of leave, but on the information the employee provided that would have allowed the employer to conclude that granting leave would have resulted in the employee being able to return to work and perform the functions of the position. If an employee requests a leave that the employer considers excessive, there's nothing wrong with requesting additional evidence and information from the employee's doctor tending to show that the leave will be effective and the employee will be able to return after the leave to work. Another form of leave often requested is intermittent leave, or an open-ended schedule allowing the employee to essentially come and go as they please. Courts have pretty consistently held that employers are not required to grant unlimited 6 days or accommodate attendance that is erratic and unpredictable. Employers should take a hard line against such requests. Perhaps the most difficult requests to accommodate are the string of definite requests that essentially result in indefinite leave. A common example might be that an employee receives a month of leave as an accommodation, and after that month, the employee requests another 2 weeks, and then that continues time and time again. Employers are generally hard-pressed to argue that a 2-week period of leave is unreasonable or causes an undue hardship. However, after a point, the employer can and should deny further leave requests. Determining when to do so is tricky, but as stated above, a good tip is to start demanding more information about whether the additional 2-week period of leave will be effective and denying the request if the employee cannot provide some information that tends to show the additional leave will allow the employee to return at its conclusion. Of course, the normal elements of accommodation law are at play here as well. An employer is required to accommodate leave through the interactive process. An employer will be much more successful in any litigation where they ultimately have denied leave if there is evidence that they participated in the process with the employee. Also, an employer need not grant any accommodation that poses an undue hardship. What might be a hardship is dependent on the business and the employee's place within it, but it is always useful to explore why a leave request may not be possible or why it would be extremely difficult to accommodate. However, instead of focusing on those elements, I would like to conclude by exploring a recent case from the 7th Circuit that will hopefully be a roadmap for other courts, the EEOC, and the legislature. In Severson v. Heartland Woodcraft, the employer denied its employee leave in excess of the 12-week FMLA entitlement. While this typically is not a good enough reason to deny a leave request for a disabled individual, the 7th Circuit saw it differently. The court started by recognizing that the ADA is a non-discrimination statute, not a medical leave statute. The court then reviewed the basic definitions and functions of the ADA and concluded that a long-term leave was incompatible with the idea of accommodation. To quote the court, "Simply put, an extended leave does not give the individual the means to work. It excuses his not working." The court determined that an employee needing a long-term leave of absence was not a qualified individual under the ADA, and that long-term leaves of absence should be handled under the FMLA. The court specifically rejected the EEOC's interpretation of the ADA as a potentially open-ended extension of the FMLA. I find this approach to be eminently reasonable. Employees are already entitled to long-term leave under the FMLA and under certain local statutes as well. There is no need for the ADA to duplicate and expand this entitlement. While one may argue that the FMLA entitlements are insufficient, This approach at least allows employers to look to the ADA when handling accommodations that are allowing disabled individuals to work, and look to the FMLA to provide bright line rules for long-term leave. If this approach were the dominant approach, the legislature could undertake to ensure that the FMLA provides the leave entitlements that are desired, and employers could rest easier. Thank you for listening to today's Working Wise podcast, and I hope you continue to tune in for helpful hints and explorations of difficult issues. As always, our talented attorneys at K&L Gates are on hand to help you navigate the thorny labor and employment issues facing your business.